ones. Nice to see you.
Hi, everybody.
We have some people still logging on. So wonderful. So while we are doing so, just one moment here. While we are doing this, we are going to reinforce, please, starting as of now, there are no black screens allowed. We have mentioned this before. This doesn't mean that you turn on your phone and you point it at the ceiling or we just see the top part of your forehead. It doesn't mean that you sit in the dark or you put your phone down and go and sit on the opposite side of the room. You will be warned by Kim in the chat. She will message you personally. If you do not comply, we will remove you and we will see you tomorrow. Hopefully with better lighting and better visibility. So doing this. So Darren, can you please give a little bit of an explanation as far as why we're taking this direction of sharing specifically?
This all comes down to timing. Is it really that practical that, you know, a few individuals with a higher level of determination are the only ones working on these documents that and these procedures that we're all trying to follow, and we're trying to escape Babylon as we know it? It's going to be, I think it's going to be much more beneficial because as I mentioned yesterday, I sit here in front of the computer for umpteen hours a day anyway. I mean, I'm already doing that. So there's no recourse, or there's no reason why I shouldn't just turn the camera on and actually start sharing the documents as we are building them. Now, for loved ones out there that are reading this particular sentence and says, oh, wow, I think we should drop this right there because that would be fantastic. Darren, what do you think? We go over it. We work on it as a team. Because this is what we're doing. We're actually taking advantage of the time, as I just mentioned. For me to build all this stuff and a few others, and then give it to everybody, and then everybody has to go digest it on their own. So that's like, see, there's two time frames at play here. Whereas we can actually just kind of smash these things into the single time frame, the right now time frame, the in the moment time frame. And excuse me, given the perplexity of the documents that we've been dealing with over the years, I think it's going to be a lot easier for us to actually walk through these things. I know we have talked about this on some of our prior videos where one day we'll be able to do this. Well, that day we're feeling is here. I have no problem taking an hour out of my day or whatever this turns into eventually to be able to just interact with people who have something to contribute. If you wish to just sit in the background and watch, I don't have a problem with that either, but just realize the more you kind of engage and the more you get involved, the more confidence you're building. Don't feel don't feel afraid of making a mistake. You think we got as far as we did without making any mistakes? My Lord, if that scale was reversed, we would have been through a long time ago and gone probably, but no, we're all being pushed into a certain direction here where, again, I have no problems working with people who are showing an interest in this. This is going to get your excitement through the roof because some of the things that we're going to be dealing with here are going to happen relatively quick. We're going to be able to get you something working here, something tangible, something that you can send off in the mail pretty quick, a simple notice to the Attorney General, a simple court proceeding, this, that, and the other. At least you're jumping in and you're getting involved rather than sitting back and watching me do it all or a few others leading other groups out there. I think this is much more better served for everybody if we all just kind of jump in. I have no problem, again, opening up everything I'm doing and building it with you guys. And as a matter of fact, I think this is going to be very advantageous because we can actually have you go and do some of the legwork in the background. We suggest, hey, we need a definition of the word recitals. Like, right here in the court procedure process where it says to insert recitals, what does that actually mean? Someone goes and finds that out. While we're even on these chats, they come back in 10 or 15 minutes. Okay, group or team, this is what I found. These types of things. This way I can be just tic-tac-toe as information is continuously streaming at us.
And what we also want to do is to give you the ability to ask your questions. So this is why we're not really because we're realizing.
Hey, Jody and Darren.
Stories different, the remedy. We don't I'm hearing a bunch of, if you have questions, you can form into the cupboard that way. So we also do intuitive pulling of questions as well.
Okay, sorry, Jody and Darren, we missed that entire last part. You guys are frozen. One moment, guys, we'll get them back up. Okay, so in the meantime, before they, well, while they're coming back, if you guys have questions, please put them in the chat. And we will, like Jody was saying, we will intuitively pull from them. And at the time of the question, if you are called to say your question, please keep it concise to that one specific so we can get through a few more and get you the information you were seeking. Welcome back.
Thanks. It's almost like somebody doesn't want us to get together or something. Few little technical difficulties. Forgive us, loved ones. We are back online. Okay, so thank you, Kim, for covering that. That was wonderful. We will want to get to as many questions as possible, so that's why we're going to keep our housekeeping real short here. We will remind you that we will not be putting up these recordings. We get asked this all the time. The answer is no. If you want our information, you have to show up. You have to do your due diligence. That's what this is about. We're doing the work. We need you to do the work as well. This is why we're doing this together. We're moving through the final stages of getting out of Babylon and really getting our freedom back, which is huge. So we won't be putting any of our forms up either. So if you're saying, hey, Darren, can you send me that? The answer will be no all the time.
Because that just turns into another logistical nightmare for us to be staying on top of who's been sent what and this, that, and the other. And that just turns into an administrative nightmare for us. So really, as we feel it's going to be easier as we post our documents and whatever workings that we're working on, you guys just go ahead and take snaps with your phone or screenshots with your computer, do whatever you got to do. And then we'll just continue. That's actually going to make our end a lot more manageable. So
absolutely. And last but certainly not least, we are going to please ask for kindness and respect at all times. We are doing our best to show up and to give this information at no cost. We ask that you just show up and that you show respect, not only to us, but to our queens and to the others that are in the room as well, please. Failure to do so will result or could result in your immediate dismissal. So we don't want to have these kinds of energies on our platform. We want to collaborate. We want to work together. So please set your intentions with ours so that this can really turn into what we see it turning into. All right. So with that, we're going to answer two of the questions that were posted from yesterday's live show. One of the questions was, and Darren, can one leave their trust in the grantor?
Leaving their trust in the grantor, that scenario sometimes happens when the beneficiary dies. Sometimes if the beneficiary doesn't have another heir, successor, or assign appointed, sometimes these interests will revert back to the grantor. We do run into certain problems with this. This is why we, in the wording and the writings of our documents, we should be accounting for situations like that. So here's the other thing: if the trust resides or only stays in the grantor and it never really reaches the hands of the beneficiary or the entitled party to enjoy it, the trust is there, but it actually didn't affect you, the weight itself. It didn't kind of activate. It didn't really do what it was served or proposed to do, which is why lawyers, for example, when they are dealing with public trusts, they spend a lot of time, a lot of legwork tracking down beneficiaries to go give them notice of certain things. Again, our gentleman colleague friend in the United States there, who's profoundly informed with all this knowledge as well, tells a story about a young man or woman is walking down the street at 21 years old. Some stranger approaches him and says, "Oh, are you such and such? Because I'm a lawyer representing a trust created by your great great grandfather, such and such a date, 1856, whatever And then here proceeds to bring them in under these trust conditions and allows the trust to flow. Here's another example. A gentleman who had a great relative serve in the Civil War. Somehow, this actually happened not long ago, made application to the court, and he proved that he was an heir to the soldier that was in the Civil War. And back in those days, if you had volunteered to serve upon completion of the war, the state literally granted those soldiers or surviving members of their family something like 10 or 20 or 30 acres and a donkey. Guess what happens to this guy a couple of years ago or a few years ago? He actually gets awarded the 20, 30, 40 acres and a donkey. It literally happens. These trust provisions, these documents, they do carry a lot of weight. The entire system is backed and based on these things. They take these securities and all these instruments very seriously, and these things do transcend. These things do transfer to other parties. It actually does happen. Again, this is not make-believe.
Perfect. Question number 2, what happens in the case of an adoption? So someone is born as one name, they take on another name. Does that mean they inherit both estates?
Well, I can speak to this one with firsthand knowledge because I'm adopted, so is Dean. An adoption instrument is actually a decree. A decree has extraterritorial effect. It's not like a simple legal order. These are much more powerful. So what does this decree in this adoption actually stipulate at the end of the day? It transfers all right, title, and interest from this name to this one. Once that transfer happens, technically we've been cut off from the other one. Now, would someone want to go try to lay claim back and establish joinder or privity to your birth family? I think you probably could if you created a birth certificate with your original birthing or born, the mother that gave life to you. If you incorporate her surname and create a whole new trust instrument, from what I'm gathering, I think that it would still be possible. Absolutely, it would be, as long as you can express an interest in privity somehow. But this isn't going to happen by default. You got placed into the adoptive family with all its rights, liberties, blah blah blah, and so on. But again, I still smell some little holes in that program where I think we could actually go back and lay claim to our other bloodline family, because any next of kin that has passed on over X amount of years, they do sort of have statutes of limitations in the legal world where surviving family members can lay claim to their equitable estates after a certain amount of years. If you check your statute of limitations acts in your area, you might find, you got 21 years or 7 years or 12 years or whatever it is. But again, those are legal constructs. So here's doctrine. This is the difference between legal constructs and doctrine. Legally, you only got 7 years, no good. Okay, so let's go around the legal. The sedicate trust, the sedicate trustant, and the trustees, that arrangement, which I'll tell you right now is completely repugnant to the rules at law, which means the rules at law don't like the whole sedicate trust idea. They just, again, because this has to do with equity, no wonder they don't like it. They turn their nose at it and they say, we're not interested. That's why we have courts of equity, to enforce those types of positions. So the sedicate trust position and the trustant position, what I'm getting at, no statute of limitations applies to that one. You could be 99.99 years old and still be acting on these things, having abandoned it 99 years ago. So again, even though we're reading something on the surface that appears to be legal, trust me, there's always going to be something else in the background equitably that will come and undo it if need be. If the at-law system doesn't provide complete justice, adequate remedy, or expedient justice, equity will come in and take over. But again, this all depends on how we coming with clean hands and coming with perfected interests and security entitlements and deeds of trust and deeds of acceptance and quit claim deeds and affidavits and so on. I mean, that there's a list of things that we should be entertaining or we should be doing in order to prove certain things exist. Again, the courts will operate on a certain level of presumption. If you can prove certain things, the courts will presume that a few other things would happen as a result of the first couple of things. So we don't need to get completely bogged down with completing this whole process A to Z. As a matter of fact, from where I'm looking at it, we only have to have a handful of components, on a plate, serving it to a judge, presenting it to a magistrate or a clerk to get the ball rolling. Some of these things that we'll be discussing here to come have already been things that we've discussed. Everybody knows the significance of why an affidavit is important. This whole security agreement thing, this has only been kind of coming to light for the last couple of years. And it's through these mechanisms that establish an evidentiary chain of events which correspond to titles. So depending on what you've done, certain titles get spit out. If you do nothing, we're left with nothing, which is why our effort here is so important. We got to do what we can to do what we can do. And this is why I'm thinking we all start kind of working together here. I think we're all going to get there much quicker. We're going to save a lot of time. Again, drama on Facebook aside, I don't care about that. At the end of the day, that's just entertainment. I don't care about any of that stuff. That's all just to drum up momentum so that people go, wow, what's this all about? Well, let's go check this out. If we can, as a fisher of men and women, if we can attract interest by just splashing all kinds of crazy stuff out there, I don't care. I'll do that. Whatever it takes. I literally don't care.
So let's pull a question from the chat. We have one coming in. Is my citizenship card the event at Vital Statistics?
Citizenship card.
The event at Vital Stats.
The event at Vital Stats.
So you're born in another country. You've been in Canada most of your life. Is your citizenship card the event?
I'm
Vital Stats.
I'm going to suggest, okay, so Vital Stats is provincial, but when you land as an immigrant, that's federal, correct? You don't show up provincially. No. That's federal jurisdiction. So once the immigration or the landing status is established federally, that title, that position legally is going to blend or bleed down to the provincial level. And then that's when it's going to hit things like Vital Statistics. That's where other records will be lodged, such as at land titles as well. So the citizenship event, again, is federal. It's not quite going to be at the provincial level, but they are very connected. We can do things with that citizenship card, like when we land, when you show this as identification stemming from your birth certificate, that's the same thing as pledging allegiance to another country. As soon as we pledge allegiance to a corporation, we've done so much karmic damage to ourselves. That's breaking the first commandment, literally right there. That's the act that puts us in the trap. So thankfully, we have a lot of individuals, loved ones, that are chasing things at the federal level, because I'm actually not spending a lot of time at the federal level. I'm trying to get the local, provincial level done first, because as far as I can see, property is dealt with at the provincial level. Once those titles are established, now you can use them to move on up to federal. So once we get the provincial local stuff sort of figured out and kind of handled and get our heads wrapped around it, we will move on. Here's another example. In one of our court processes that we're developing right now, we must, it says it right in the legislation, send notice of what we're about to do to the provincial attorney general and the federal, attorney general. That tells me we're dealing with, some pretty significant subject matters, because very rarely do you ever see that as a requirement or a prerequisite that we must notify in another jurisdiction altogether. So again, there's some substance, there's some pretty important stuff hiding in the background in some of these documents, which is why it's up to us to go and do a little bit of research, do a little bit of due diligence, and keep this flow going.
So speaking of doing due diligence, let's get on to this document. We're going to be sharing it with you. So let's move into this. This is actually one of the reasons why we can't just send our documents to you, because they are always and forever changing. And even today, Darren was doing some last minute pop-ups here on, sorry, that was a pop-up, some last minute adjustments here to the affidavit. So I think we probably have 3 or 4 versions of this going now. So he's going to take you through it, help you understand what this all means, the certain words. Again, if you have questions, drop it into the chat. And without further ado, here is Darren to talk about the special affidavit.
Okay, so this is essentially the same affidavit that we were posting online here, a number of months ago. That was part of our adverse claim package, if you will. But just sitting down here a couple hours ago before this meeting right now, I just added a couple of tweaks to it. Now, again, this is where the affidavit becomes important, because this is the mechanism, this is the conduit, this is the thing that starts to establish, which is a very important word, establish our whatever it is we're looking for. This is where we can start to prove things exist just by stating it, just by claiming it, just by expressing it. As a matter of fact, at the bottom of this document, there's a little clause that I pulled out of one of the equity books from, the mid 1800s or late 1700s or whatever it was. It's a beautiful little way that dials things in and presents it in a beautiful little package so that a judge, or again, a clerk, etc., would actually be able to look at the tangibility or the enforceability of what it is that you're trying to do here, which is why they're always asking for state the material nature of your claim. That gets a little bit tricky. Again, as I mentioned yesterday, I've spent a little bit of time researching, okay, what exactly constitutes material evidence? Because they don't want things that are relative to the evidence. They just want the evidence. So take this with, a blessing though. What that's actually going to do is streamline everything. If all we can do is talk about facts, not how much we enjoyed the weather today, did it rain or not? I don't care whether you enjoyed it, right? That's kind of what we're after. People say it rained today, and then I went outside, and I played in the garden, and then I did this, that, and the other. The judges don't care about the other. They only want the true, concise facts. So go ahead and start taking screenshots of this, whatever you want to be doing. Again, this was posted a while back, so you may have a copy of this. I'm just going to let it sit here for a minute so that you can take the screenshots, do what you want to do. We're going to go over this in a minute here. So this particular document will be up for, maybe 20 minutes, half an hour for the rest of this hour, as a matter of fact. But what I want to be describing here is some of the elements in the paperwork that we were talking about yesterday with that other loved ones, a couple attempts of getting things before the Attorney General and the courts. Some of the wordings and some of the phraseologies and some of the substances that he was dropping in that little letter are significant. He did, again, given the time frame back in the day, and his level of awareness and where he was able to drop a lot of decent stuff. So what I'm suggesting here is go ahead, take some of that stuff from yesterday. Take out the best parts. Start incorporating it. I hate that word too. Start folding it in, start utilizing it, start getting it involved with these affidavits. We actually wound up using 2 affidavits once our court case started, because I realized there's a couple of deficiencies in the affidavit itself. So we went back and we developed the second affidavit. We can always develop affidavits. They're supplemental. That's what they're called. You get one to get the show started, you leave it, and then you just kind of keep supplementing to it. And that's done with other notices and, correspondences to the judges, whatever it is, the situations that we're dealing with here. But this is just a simple kind of an affidavit. Again, this is going to be very open to tweaking, very open to adjustment. I'm just trying to lay a little bit of groundwork here to get the ball rolling. So back to the start here. I used to have 2021 in Liber right here. I must have missed it on this one, but in Liber kind of fell in my lap not that long ago. In Liber, when I went and researched that, it started to immediately talk about some of the elements that we're talking about here with the trusts, the expressions, recording at land titles. It started talking about birth certificates. It's like, okay, as soon as I saw that, boom, I saw a value to attaching in Liber right to the date. If you want to go and do a little bit of research on that one on your own, go ahead. There's a little bit of a trail there. So again, what kind of affidavits are we doing? Never, ever, ever be referring to ourselves as general. General means public. Never use that word generally describing yourself. The only time I use the word general is when we're praying for relief. There's general relief and then there's specific relief. What's the difference? The general relief is the basics that you're entitled to. Okay, the court system knows you're probably going to need this, that, and the other, and some of these and a few of those. Okay, but is there anything special you need? Oh, yes, Your Honor, I require blah, 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 and blah, blah, blah. Okay, there's the special and the general. General is public. It cannot describe your special remedies that you're praying for. How can the outlaw coded system get in your brain and know exactly what it is that you're trying to do? So the distinction here is actually pretty important. I will never refer to myself as general. So classify your affidavit as something. Every time that you have an opportunity to say, what's the nature or what's the context I'm trying to describe here? Or what is this event? Is it special or is it general? Be liberal with that word special. Throw it around a lot. Don't be afraid of, oh, I've used it 4 times on this page. The judge is going to get mad. Yeah, no, that's not how this works. So this special affidavit is in support. That's a big one. That is suggesting right there that without this affidavit, most of my house of cards would fall down. This particular document supports everything I'm doing, and now I'm just going to use it as a mechanism to lay out, almost like a menu, what I plan on eating today. What's my daily feeding requirement? Well, Your Honor, we're going to start dropping down some material facts for your consumption. Now, again, we're never really criticized with the construction of an affidavit. We're never really criticized with elements of our affidavit that go sideways. Again, the judges will just read through them. They'll get the gist of it. So even if, again, this isn't about making this part perfect, although I would sure like that. Where is perfect? Do we even really know what that is? Again, as an artist, I'll do an oil painting and I'll come back a year later and stand at it, look at it for 30 seconds and go, wow, I could have done better there, and right? So we can always be developing. Point is that we don't want to start taking these 1 or 2 page documents and turning them into 30-page documents again, just because, oh, I wanted to add this, and oh, here's a little nugget here. You know, again, there becomes a point of redundancy where, okay, the judge can get the gist of what we're doing. So we're supporting our surrender for redemption. I've spoken about surrender a number of times. Again, given what I have come to appreciate about Scripture, these 2 words are pretty important. When we're rendering, when Christ asked his disciple there to render unto Caesar what belonged to Caesar, and he shows him a coin and says, whose inscription is this on the coin? And he says, well, Caesar. And then Christ is literally saying, well, then doesn't it belong to Caesar? Give it back. Okay, so who does this birth certificate, chattel property, certificate of security, whatever you want to call it? I mean, there's a number of words we could even use here. That item, that instrument, once it is dealt with, once it is perfected, once it is rendered. What does the word render even mean? It means you're taking something and transitioning it. You're actually, when you render beef, what are you doing to it? You know what? You're actually boiling it down, are you not? You're putting heat to it. You're liquefying it. You're doing something. That thing is changing. So when we take the coin or the birth certificate and we go now to render it, you better do something to it in order to render it. Well, what could you do when you're caught in a war and you run out of bullets and your flak jacket is full of holes and you see a whole bunch of guys running at you? You know, some people might crawl out of the hole and wave a white flag. What an incredible moment in time for that individual. You're hoping that you're not going to get shot, and you're hoping that these individuals who are trying to kill you are still going to honor the rules of engagement. I wouldn't want to be in that guy's shoes. That does not sound like a fun deal. However, we're dealing with the paperwork version here. We're trying to clean our hands by no longer coming in war or in an adversarial possession. We're trying to settle our claims. We're trying to stop confusion of titles. We're trying to remove a cloud from a title. So again, that word rendered has huge implications. Surrender, terrific. No one can say, no, you can't surrender, go back in the hole. Not in keeping with equity. Grantee, as I was mentioning yesterday and other videos, super important. This is something Dean and I missed for, I'm going to say 15, almost 20 years. We always used to propound to people, grantor beneficiary. Well, here's the inherent problem when you claim grantor beneficiary. Which one? As soon as you put grantor /beneficiary, you're playing on very thin ice. You're saying there's a slight distinction between the two, but you actually haven't told the judge which one it is you're doing. So when you show up as grantor and beneficiary, guess what happens? No trust. You can't be the grantor and the beneficiary at the same time. It's impossible. If you do, you literally just self-defeated or self-destructed the paperwork or the position or what it is you're trying to express. So I would much rather have had us back in the day say, oh, at this particular time, Your Honor, I'm the grantor. Draft a whole other document. And at this particular time, I'm the beneficiary. At this particular, draft another document. At this particular time, I'm the grantee. The grantee is the guy, the gal that has an understanding or an awareness that there's two titles at play. And as the grantee, you have possession of both. Can you imagine the crown is loosely holding your equitable title, even though they're actually not in possession of it? Would you believe that you still actually have the equitable title? It's actually in your back pocket as well. Problem is that the legal title that we volunteered for trumps it. That's the big problem here. The legal title enveloped the equitable title, and now we have a tough time, or people have a tough time regarding the equitable title when we appear to be acting legally all the time. So you see there's a bit of a conflict here. There's a bit of a discrepancy. There's a bit of a confusion. So again, grantee is very solid position. I have both of these things at the moment. I can prove it in my affidavit. Why? Because I claimed it. Here, I'm just going to go to that little blurb I was mentioning a second ago. I love the way this reads. Again, these aren't my words. Right here. And the above equities are believed. Again, if you want to change the word believed, I know many of us don't like that word. So I'll continue. And the above equities are believed to exist and are just and are adversely claimed for the benefit of the person or individual making this special affidavit accordingly. So right in there, when you're saying that you know these things exist, who now can come along and say, I'm going to take my knowing and say, no, you don't know? That's silly. Again, just that doesn't even make sense. As soon as you know something, how could that ever be taken away from you? Well, yeah, okay, you jump into a swimming pool, you hit your head at the bottom, you come out not so good. Okay, maybe now you won't remember. Maybe now you'll forget. Maybe now you won't act in that capacity further. Maybe now you've lost your equitable title because you'll never remember it again. Point being, you've always had it this whole time. Moving forward, grantees got both, and as such, I can get rid of one of them. When the operation of merger happens in equity, it allows for one of these titles to be stripped off and granted, assigned, conveyed, transferred, delivered, devised to another party. Here's another one, appointed. Believe it or not, there's several avenues we can take to put that title into the trustees' hands. Now, we're going to get into another little sidebar here in the next day or so, where we're starting to talk about, okay, how many trusts are actually going on here? And then we're actually going to have to start to look at this a little bit deeper, because I've always felt like, you know what, when the trustees are acting properly and they get paid and they get to enjoy their lives and they're kind of, everything's kind of hunky-dory for them too, isn't that kind of a form of benefiting from something? Of course it is. So then why would some of these equitable doctrines be saying that equity's profound purpose is to make sure both parties are satisfied? Okay, well, if I'm receiving the beneficial enjoyment of property, and these guys are kind of receiving a beneficial check from from our estate or our life estate, that is a type of benefit. So at some point here, we need to almost consider, okay, well, if I'm giving that legal entity back to the state under one trust, maybe I'm the trustee of that, granting that back. Now they're the beneficiary of the thing that they created. Now they get to take that thing and sell it. They get to take that thing and go do some stuff. That's one particular trust. So what would the resulting trust be? Or what would another trust, what would the trust that defeats the first one? This one, we're entitled to enjoy property as well. But you know what? Here's an example. If I'm serving the Lord through Christ, am I a trustee or am I a beneficiary? Who's benefiting by us being obedient and serving unto his word? I'm going to say both parties are benefiting. I'm going to say creator benefits because she likes it. And we also get to receive a bit of a benefit as well. So this actually starts to get a little bit confusing. And I know there are so many texts and books and statements and proposals and paperwork through the yin yang going back hundreds of years trying to explain all this stuff. But you know what? At the end of the day, it's still a little bit confusing after you just read a 300-page book on equitable proceedings. You might have to go back and start reading it again because it's designed to confuse us. We weren't really meant to just come into this information and go execute it tomorrow, tickety-boo, all done. No, there's supposed to be a journey involved here. And by journey, I'm going to suggest that is going to be more than the course of a weekend. The journey itself is the work. It's the effort. So much enlightenment, so much enrichment will come to ourselves once we put the effort in. Looking back at this little blurb here, I know I'm actually missing one thing here. The above equities are believed to exist and are just. Claim for the benefit of the person making it. So you know what? For tomorrow, I'm going to upgrade this one because this one, it's short. So I'm just going to be honest with you guys. But point to my statement here was, this is how we prove things exist, by saying so. How did that whole other dimension, if you want to call it the commercial world, how did that whole thing even start if something real wasn't actually happening in the background? If people are coming online now and they're suggesting, oh, you got to prove that thing's even real or prove that it exists. Well, when I'm in possession of a security certificate and I'm in possession of a little bit of knowledge and I put the two together, I can create things and I can extinguish things. That's the beautiful thing what equity is going to do here for us right away. Again, I don't care about the $100 billion in the account. Give me one silver dollar. That's all I need to go trump and extinguish legal tender. I'm not after a bank account that's got $100 billion in it. Not at all. I know that's drive or that's motivating for a lot of people, but that's not how it really works in the background. To extinguish debt means that you literally owned it, got rid of it, did somebody else a favor. Now you can stand in their shoes as a creditor, in a loose kind of way to explain it. But now that you're standing in their shoes, that's the subrogation part. That's the other element here that we've been chasing for a number of years. We were born into this debtor-slave ship position. We do something with the titles, with the certificates, add value, put it into the other's hands, and then subrogation happens. And now you're entitled to enjoy or reap the benefits. So for these individuals out there now saying, oh, you got to prove these things exist. Yeah, well, I basically agree. You prove these things exist by putting your hand to paper, by putting your paper in the hands of others, by expressing proper interest and intent, wrap all these things up with a beautiful little bow and done. Who now is going to come back and say, well, that doesn't exist? It's like, okay, maybe we're going to have to work on the definition of exist. I don't know. But point is, this is all starting to feel pretty real. The problem is, when certain titles don't exist, we have no leg to stand on. We have no position to enforce our entitlements. That's where these friggin' certificates and negotiating these things properly is going to start to come into be, very handy, very important. As Dean and I and many other loved ones have been chasing this freaking game for our journey for a long time. So this little affidavit, this is one of two. We can go over the second one tomorrow. The point here, what did I do? This is my tech skills at their finest.
Just have you minimize the window.
Okay. All right. Okay. Okay, so when we're talking about the protected purchaser, again, this is the position where an entity attaches valuable consideration. It could be silver. It can be love and affection. They took love and affection out of the paperwork, though, because I'm thinking once you're declared to be a dead, you are not capable of expressing love and affection if you're considered dead. So they literally actually took that right out of the legislation. They kind of repealed it right out. So what are we talking about here at the end of the day? Well, we're going to be talking about quick claim deeds. Quick claim deeds, two things. I think we should even construct two quick claim deeds. If we can show up as the fiction and grant something to our natural state of being, as our natural state of being, would we also want to grant something to the estate or the fictional state of being, right? You got factional and you got fictional. There's two states of being here. The protected purchaser shows up with a quitclaim deed saying, I quit claiming to be primarily liable to a security interest attached to a particular certificated security in registered form. I quit claiming. Because remember, when we took that birth certificate, we went and made federal application for a social program. Right there, we volunteered to be liable for that instrument created by the province where you're living. We're saying, wait a minute, I made a mistake. That particular certificate belongs to the state. Therefore, I'm going to quit claiming to be responsible, liable for it. Pretty important. We're going to embellish on that as we go here. The declaration, we all kind of know what those are kind of doing. These are going to profess a bunch of facts, dates, evidences, material things, this, that, and the other. It's going to set the stage for something that is setting the stage for an event. Is technically all a declaration really is. A trust deed. Okay, deeds are very important. In the next day or three, I actually have my trust deed that I'm developing right now. It's pretty tuned. I feel as it sits right now, it will pretty much get the job done, but I'm going to be providing it for you all here to see so we can work on it. Fantastic. I'm thinking. Next, the vesting order. Okay, this is where the object of my suit, Your Honor, is to vest the legal title in new trustees. And according to the Trustee Act, Section 29, this section allows for the appointment of new trustees, right? You'll find it. It'll only be one chunk of legislation you need to affect this. I do have that other loved one colleague, fantastic gentleman in the United States I keep referring to. Again, this is the same guy. I don't want to divulge his name. I'm not at liberty to do that. However, he made a lot of progress with just using exclusive equity. But then, as far as I've heard lately, there was stalls, there was problems, there was points of contention, there was parts missing. I haven't talked to him in a couple of years, so actually I can't really attest to his situation at hand. But that was kind of part and parcel as to where it was lately from last time I heard. So what I'm suggesting here is this: you got legal, you got concurrent, and then you got exclusive equity. That's kind of what's going on. You got one extreme, you got the gray in the middle, and then you got the other extreme. I'm not opposed to using concurrent jurisdiction a little bit, because legal certainly recognizes it, equity can see it. So I'm not opposed to playing the game there a little bit in the middle. Because I've actually, back in the day, 4 or 5 years ago, I rolled with my buddies' enlightened ways, and I drafted some straight up exclusive equitable stuff, sent it in, and the responses were like, no, we don't get it, we don't get it, not entertainable. Now, I could probably go back and figure out and dissect, and okay, yeah, that was a little weak, and I kind of shot myself in the face there, and that probably wasn't very good. Point is, I don't mind when we're constructing these deeds, when we are establishing a new trustee, is it the end of the world to say, and the new trustees shall also adhere and follow and be bound by their own trustee act? When I said their own act, is it mine? No. Should my documents now be fatal because I inserted that clause in there? I'm going to say no. If the judge doesn't like it, he can read the spirit and the intent of what it is you're trying to do. Again, loved ones, this is the beautiful difference between equity and the legal at-law system. The legal at-law system doesn't give a shit about your intent. It doesn't give a shit at all. All it cares about is black and white. What did you do? What did you not do? As a consequence, that's it. Boom. One party gets destroyed and the other party gets everything. It's not balanced. That's why the world is in the state of affairs that it's in, because it's entirely run legally. There's very little people doing the equitable stuff, causing little miracles to happen in the background. So moving forward, we're talking about a lot of chief material facts. We're stating herein that we're of firsthand knowledge, and we have the ability to attest to these things. Again, this is all just standard affidavit stuff. This is pretty generic. But this is what we're going to start getting into, where we start laying down some actual facts that on or about this date, the grantee in possession of absolute title, otherwise fee simple absolute, respecting a particular certificated security in registered form, chattel paper, identified as here's your little legal description, registration, et cetera, et cetera, et cetera, was either assigned or surrendered for redemption to new trustees, debtors. And again, I actually didn't even finish that other statement I was making, but this just reminded me of it. There's a few ways to get that title out of our hands. We can assign it, we can deliver it, we can transfer it, right? Here's the other one though, the private appointment under a security agreement. Once you do that, and literally it's only one sentence. If you do it this way, you actually don't have to do it under the terms of a conveyance. Conveyancing, if you actually go look at conveyancing under the land titles program, conveyancing gets a little sticky. It gets a little bit tricky. It gets a little bit ambiguous. It's like, oh my God, I just jumped into a rabbit hole on this particular word, conveyancing. Assignment is another one. To assign an interest, a whole bunch of shit has to happen in order to assign that thing effectively. Keep in mind, these processes do work. All I'm suggesting is there's another one here that's more simple and trumps those two. A private appointment under a security agreement gets the job done. What do we do with this security agreement? Again, this is what I've alluded to in the past. Once this from the debtor's position, remember, because you're presumed to already be in that debtor position, so why fight it? Believe it or not, the debtor actually has a little bit of powers and has a little bit of stuff that they can do as well. If you stipulate it properly as the surety to the debt, we can do some stuff. So I'm saying embrace that debtor position because you're deemed to be in it and we haven't gotten ourselves out of it yet. So let's just roll with that one. It's just going to be easier. Once we actually have that debtorship perfected and we've got it boxed, we've got it in a nice little package, and now we're sending it on its way. We are reporting it for reclassification, re-rigging, retrofitting, these types of things. Reclassification, if you did a little bit of research on, you might, I know a number of you would have seen this probably when you're looking through legal documents and court cases, a class of individuals or a class of persons. This is a bubble. That's what this is talking about. This is talking about a specific group that has slightly different somethings than the other class, and then of the other class over there. There are differences here, and that these particular individuals have the ability to exercise these slightly different rights or liberties, if you have it. You don't want to be classified as the debtor, where we want to be reclassified. That's going to be one of the little keywords in the background that helps us move from that title to a better one. Again, as I was suggesting yesterday, a court of itself will not presume a party to have a better title or better claims to equity other than that which he discloses. Again, there's a little bit of chatter online right now about you got to prove it. Does it exist? How can you prove this thing exists? Well, with a little bit of effort, I'm thinking that that's actually pretty doable. Otherwise, how the hell did we get in this mess to begin with? If it didn't exist, there are things going on here. So the fee simple absolute is something that we need to actually look at, because this is actually, it's legal, it's equitable, it's a hybrid, it's in all worlds. All the systems recognize what this is. You have a state of a title, and then you have parties to this title that need to be identified. So, for example, a fee simple defeasible title gets lodged in the new trustees. It's defeasible. Someone can come along and adjust it, cut it down. They can do stuff with it. When that title is indefeasible, that means no one can come down and cut that tree. It's indestructible. That's a better way to say it. So we put the destructible title into the trustees' hands for the legal purposes, and we take for granted the equitable on. Again, I don't think we have to spend a whole lot of time going to the court or going to the attorney general saying, give me my stuff back, give me my stuff back. What if they actually don't have it? What if you actually have it? Because again, I've seen it in the legislation where it says, although the crown is not in actual possession of the escheated estate or the unclaimed property, it's like, well, okay, wait a minute. What's going on here then? Either they got it or they don't. Well, what they're saying is that because no expressed intent was ever applied to a certain situation, they kind of can swoop in as administrators and kind of take on a role and deal with the property, the interests, the rights, the liberties, while you're absent. So do they actually have it? No. but you don't actually have it either because you actually haven't shown up and presented it properly. See the bit of a conundrum there? So when we actually come forward, right, and we actually start expressing these things properly, these things can exist. Why? Because doesn't the power of the word create? Well, if I can create with the word, doesn't that now exist? Come on, people, we gotta tighten up our game a little bit here. Now just a matter, again, just to finalize that before I leave it hanging. Now it's a matter of going and getting that idea dealt with, get it recorded, get it lodged, get it before a judge. And here's why I want to go to court. I know I said this yesterday in the one of my posts. This is why I want to go to court. Court says this: if you go start a security agreement on your own with a party and you get halfway through and you run into a problem and now you got to go to court to deal with the problem and you create a whole big freaking mess, court rules basically say this: why didn't you come to the court in the first place? We could have helped you get all that bullshit dealt with so that now you wouldn't be wasting court time now. Because now the court has to go and undo a whole bunch of shit. That's actually wasting court time. So get the courts involved early. They're actually, the judge is your advocate if you come with clean hands, if you come with, proper stuff, and not a belligerent fuck you attitude. No, come on, let's clean up that. I know that was entertaining 10 years ago, but let's move past. So we're talking again here, we're talking certificated securities, the interests, the successors to an interest. The crown is a successor to the legal interest once we're done with it. I'm so tired of serving two masters. I'm taking this one and granting it back. That's a big deal. We can literally donate that legal interest. Here, as the donor and as the donee, you now owe me something because I just gave you something incredibly valuable. Why is it valuable? Because here's why. Under the doctrines of trust, once we put that certificate of security perfected with valuable consideration and all these other supplemental and supporting documents and instruments in the background, do you know what they do with that certificate? They sell it. They lease it. They mortgage it. They rent it. They go make money from it. That's the whole point. So while they're doing that, where's all the proceeds going? Where's the rents, accruals, profits, monies, interest? Where's all that flow to? This is why we have to establish, well, that would be me over here with my hands open, waiting to benefit and enjoy it once you guys sell it. Are they entitled to percentages and profit margins and portions and blah, blah? Yes, that's all part of the tithing. That's all part of the 10%. That's all built in. Again, that whole 10% thing that Divergence punched out years, a number of months ago, that was just to see how people are going to react to a situation that's already carved in stone. I cannot control the tithing process. That's locked in. The 10% was already going. That's the Levitical priesthood. I've mentioned that a number of times in the past. And shit, okay, I know we've only got like 7 minutes here again already. See, again, this is where, okay, as I posted today on setting the stage for tonight's event, there's going to come a time here, and I'm thinking pretty quick, where I have no problem spending 2 hours a day doing this for people. Come and go as you please. I don't care. I'm here to help you. If you have an appointment in 5 minutes, go. I'm not going to penalize you. We're not going to say, well, this, that, and the other. You'll only observe, and you'll only benefit from putting some time in. Again, me and many other loved ones, even on this list, I've already seen a few names here who are some pretty heavy hitters. We contribute as a group with a loving fashion and direction behind it. And guess what? We will all get there quicker. And I would like to get there quicker with your help. Do I like sitting here doing paperwork for 16 hours a day? Some days I do, some days I don't, to be honest with you. Some days I like to be doing other things, but I'm not in a position where I get to enjoy a lot of those other things because I've kind of committed myself to be doing something pretty important here, and I will just see that through to the end. Here is another blurb that's actually talking about the fee simple stuff. This one right here, number 8. We have to actually establish that such and such a party, if you want to put certain names in here, whether it's the all caps name or whether it's the proper styled name, point is there's an entity here transferring something to another entity here for that party's heirs and assigns and successors and things forever. Now, forever is a term of limitation because it kind of defines. what the scope of time is. This is going to be something pretty important as we develop here. I just set this in here just a few moments ago. This is not the final version, friends. This is just to get your eyeballs tickled. We got to go back and say, property in my possession must be put into the possession of that that party for the purposes of. And once that has taken effect, now these obligations, duties, other things will arise. That's how we create these trusts. No trust is created when nothing actually transfers. If things aren't moving around, trusts do not arise. That's the way it works. So yeah, okay, so we're talking decrees. Again, I mentioned this in the adoption statement a little bit earlier. Decrees are very important. Decrees are an equity. The legal system doesn't really decree anything. They don't have the power to. That's an equitable thing. So we're gonna, attach to this special affidavit, we're going to attach quick claim deeds, we're going to attach trust deeds, we're going to attach security agreements, we can attach administrative agreements, we can attach all kinds of stuff to our affidavit to get this before a judge. And here's when you make a short order requisition to get your stuff heard by a judge right away, you actually don't even have to attach any of those documents. Actually, believe it or not, they don't want to see it yet. They just want to see this kind of in memorandum form. Okay, what do you got? Oh, you got a quick claim deed, you got a trust deed, you got a security agreement. Okay, well, as the judge, based on what I've read right here, I'm going to need to see your trust deed, please. Can you please forward that to my office? That's when you would now send that in. You don't need to send it. You don't need to send your birth certificate in the very first volley, if you will, although placing original instruments into the possession or having them falling into the hands of the judge is critical. They must have the originals, okay? So life tenant, life estate, these are two big ones. A life estate can only exist in equity. So when we're attaching things that only exist in equity to our name, or whatever variation or portion of our name we happen to be using, you can see why that's important. So now that we have a thing, we have an entity established, now you kind of show up as the tenant of that thing. Now you can do a little bit of research on joint tenant or tenant in common, things of this nature. The joint tenancy thing, there's a little bit of a rabbit hole there if you want to go down it, but it wouldn't take you very long to say, okay, it's just two different parties acting in two different respects to a particular agreement. That's all that's really going on here. And again, protected purchaser without prejudice, those are pretty, we got those ones figured out. In closing here, loved ones, this is what I want to be doing. Pretend this is the actual working document that we're dealing with. And I'm on number 7, and our friend here, Mason, says, Darren, when you got that declaration, let's put a little something right here, because look what I found. We would all, as a group, take a look at that and go, hey, you know what, dude? That's the shit. I didn't see it before. Again, even though I've spent years, I couldn't even count the amount of hours that I've spent working on this stuff. Do you actually think I've seen it all? I'm gonna throw it out there that I've seen a fraction of it. That's it. So you see how we actually kind of depend on each other to help each other out. That's actually really important at this stage of the game, and that's why I'm doing it this way now. Now, keep in mind, this is going to start for 1 hour. I have no problems doing this for 2. I have to coordinate this with the queens, because even putting these things together, it still takes a lot. We're busy doing a whole bunch of other stuff, and now I just threw this at them the other day. Point being, I know as a group and as a unit, a legion, as opposed to a religion, we are going to be able to get this done. So I'm actually calling on everyone for their aid and assistance, whoever wants to contribute. That's how this is going to start to unfold and progress from here. I would love to spend more time on here, and I'm gonna. So if you choose to show up, I encourage you to come and go as you please. This is going to be an open forum. There's going to be nothing expected other than whatever it is you're willing to contribute, whatever you're willing to offer, whatever that you can provide. When you go do a little bit of research, you're actually excited when you can come to a group who appreciates your work, who recognizes the value in it. That's the stuff that gets you up out of bed a little bit earlier. That's the stuff that makes you fall asleep a little bit later, right? Your sleep schedule starts to go a little bit wonky because there's this crazy, energy that starts to come through all of this. I've talked about it for years, and I want you all to be a part of it, rather than it just be me, and then I go make a video about it a month later. You know what? Well, why don't we just experience it together in the moment? Why? Because I have nothing to hide. Thank you, loved ones.